All right, we're going to get started. Hello, welcome everyone. We're going to get started on November's Planning Lunches at Noon webinar, Investigating and Enforcing Land Use and Zoning Violations. Thank you for joining us. I am Brendan McDowell, a principal planner in the Office of Planning and Development at New Hampshire Department of Business and Economic Affairs. I am joined by Stephen Whitley, attorney with Drummond Woodsum Attorneys at Law, and Shane Conlin, Code Compliance Officer from the City of Somersworth. So they've got a lot of information to go through, but before we dive into this topic, here is a reminder on how to use Microsoft Teams webinar controls. Please drop your questions in the chat, and at the end of the presentation, we will go through as many questions as possible. And with all that out of the way, let's dive right in. So, Stephen, you can take it away.
Excellent. Thank you very much. So I am got control now, so it's all up to me. Okay, so good to have all of you here. Thank you for the invitation to allow me to present. This is a great sort of approach to have, a compliance officer as well. So I'm happy to do this with Shane because I think you guys will get some really interesting perspectives on how each of us sort of see this process. So I'm just going to start out here with maybe what's perhaps overlooked, and that's how do you get the information that forms the basis for an enforcement action? Most likely you're going to get it in the form of a complaint. And that could either be oral, like somebody walks in and tells you about it or tells your enforcement office about it, or they do it over the phone. Written is preferred. It's just better to have that documentation on hand. If you do get it orally, I suggest that you memorialize that in writing so there's a record of it shortly after the time it was made. Some communities have a complaint form where it's easy to fill out and provide to people. That's always a good option. Just know that written complaints, those are governmental records. And so when someone does submit those, they are subject to disclosure under 91A. So after you get the complaint, the next thing is, you need to investigate it. Is it credible? Do you need to take action on that complaint? And so sometimes this is a lot easier than other times. It really depends on, what you're inspecting for, and can you discern the facts on the ground easily? Or do you have to take some additional steps to be able to evaluate that complaint? Certainly you can do a drive-by inspection, and that is, usually one of the first steps. You can do that from any public right-of-way. But the tricky part is obviously you're limited in what you can see from the right-of-way. If you have neighboring landowner consent, you can enter private property, not the subject property, but on either side of the property in question, and you can do an inspection from that vantage point. Google Earth or similar sort of websites can also be really useful because you can get a bird's eye view of the property. Just note that the date that picture was taken may no longer be the condition of the property. And, depending on what you're investigating, it may not be super useful, but, I've used those tools before. If you're not able to, investigate the way you want to, you may have to resort to some other options. And first, let me just say, do not enter the subject property without the owner's consent. That really creates a host of issues, and it also, frankly, can create a conflict with the property owner, which we really hope to avoid. If you can't get on there, there's a process where you can go to district court and get what's called an administrative inspection warrant that will give you permission to enter the property even without the owner's consent. And once you are able to do your evaluation, document, 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 photos, video, descriptions. That's really important because if we end up in court, that is part of the evidence that we're going to use to show that a violation is in fact occurring. And so, the how well you document it in pictures and videos and descriptions, it really can be an important piece of the enforcement process. So notice, once you do that and you figure out, hey, there's a violation here, then you need to give notice to the property owner and inform them of the position of the municipality of whether they're in violation. And here, I want to focus on the bottom here. This is really a key part of it. Your notices, they really need to be specific. Okay, so if there's a violation of the zoning ordinance or the subdivision regulations or some other local code or regulation, you need to cite chapter and verse of what is being violated. You don't necessarily need to provide the actual text. Some communities do. They say you're in violation of this. Here's a block quote of what you're violating. I've seen other communities, attach that page of their zoning ordinance or their subdivision regs. Those are all fine. I don't think you have to do those, but you do need to cite the chapter and the subparagraph or whatever with specificity so someone can go to the town zoning ordinance and look at it and say, oh, that's what they think I'm violating. In addition, please also include some sort of description about the facts that support the determination there's a violation. So I don't think it's sufficient to say you're violating this provision of the zoning ordinance. You need to go a step further and say, here are the facts that our inspection uncovered. These facts support our determination that a violation is occurring. So once you get all that in the notice, it needs to be sent out via mail, certified mail, so you have a record of it, return receipt so that you can document if they sign for it, and regular mail. Okay, the people that are the subject of this, they can be savvy about avoiding getting those mailings, right? And so you send it regular mail as well, to at least create a presumption that they in fact received the notice, even if they don't sign the certified mail receipt. And sometimes hand delivery is necessary. You can post it at the property. And just, I think most of you guys probably know this, but if you're interpreting the zoning ordinance as part of the enforcement action, then the property owner has the right to appeal that interpretation to the ZBA. So let's say you do that and then nothing happens or not enough happens. So, what are your options? Well, broadly speaking, there's two sort of forums where this could end up. It could end up in Superior Court or it can end up in District Court. Superior Court has, broader powers that they can bring to bear on this. And they have what are known as the equity powers. That's the authority of a judge to say, you must do this, or you shall not do this. That's at Superior Court. That Superior Court's also usually better if it's a more complicated issue. Just the judges, frankly, have a little more time to sort of spend to wrap their heads around what the issues are. Superior Court can be a more intimidating place, both for municipal witnesses and for the other side. It's also probably lengthier and more expensive. So the alternative is District Court. District Court is a great avenue depending on what you're enforcing. That's where your cease and desist orders go. Pleas by mail are also going to go there also. And it's good for, really straightforward violations. It's probably quicker and it may be less expensive depending on what happens. But finally, self-help is never a recommended course of action. Okay, if that is inviting a countersuit or counterclaim against your municipality, if you are taking self-help without the authority of the court to do that. So please, please don't do that until you check with whoever your legal counsel is. Let's see here. Okay, so I mentioned this already. You really need to be specific about what you're enforcing, and depending on what you're enforcing, you need to think about who is signing that letter. Some communities have different individuals that wear different hats, right? You have someone that is your zoning enforcement individual, and you may have someone else who does who's the health officer, or your state building code enforcement. And so you just need to think about that when the letter is being signed. Um, Generally speaking, I know a lot of you are land use board members. Generally speaking, land use boards don't have enforcement authority. That is reserved to your municipality's enforcement arm of government. And so that's usually your governing body. And if you have staff, such as a code enforcement officer or zoning officer, they're usually delegated with that authority to enforce. There's one exception to that, at least one that it's worth mentioning now, and that is planning boards do have the ability to revoke site plan or subdivision approval if there are violations. So in that instance, that land use board, the planning board, does have some enforcement authority. And when we're talking about what the actual penalties are, this is sort of the laundry list of options, or at least the ones that I see and utilize the most. The one at the top there, injunctive relief, that's the one I mentioned that is exclusive to Superior Court. That's the, violator shall stop, whatever. Violator may not continue in the future to do whatever. The next one is civil penalties. I find that civil penalties are more of a negotiating tool than something that's actually awarded by the courts. And so when you send out the letters and they say, hey, if you keep this up and don't bring the property into compliance, for every day that you continue, there's you're going to accrue a daily civil penalty. When you add those all up and it's some big number, like tens of thousands of dollars sometimes, usually the courts don't award the full amount of those penalties or don't award them at all. It really depends on how the behavior of the party in question. If they're a really bad actor, you might get some of that, but a lot of times that just doesn't happen. Attorney's fees, on the other hand, if your municipality goes to court and you prevail, by law, the attorney or the municipality's attorney's fees are awarded to your community. And so that is typically something that is in fact awarded. If you're doing a cease and desist order, that's the 17-A one there, you are in district court for the rest of these. The cease and desist order, it can include fees and costs. The cease and desist is usually what results from that is a summary enforcement order from the district court or some other order from the court if there's a contested hearing. And that order can contain the award of attorney's fees and costs. The other sort of nice thing about the cease and desist option is that that amount of money can be collected the way that your community collects taxes. And so it can form a lien that's then placed on the property, and then the property owner It's just like the property tax process. If they continually don't pay that, arguably your community has the ability to deed the property for non-compliance, for non-payment of whatever was awarded by the district court. The last couple here, um, I don't see these as much, or I don't, maybe they don't really get sent to me because they're resolved by these, and so there really is no dispute. But these are for the more straightforward ones, where there's a fine that's due, and the person in question, basically doesn't dispute it and says, okay, I'm in violation. I'm going to pay this amount, so that this goes away. Um, but again, I mean, my practice is typically the first four up here. So I want to, before I pass this on, I just got a couple more things I want to mention, and I realize I'm going kind of quick, but I wanted to make sure we had time at the end for questions. The other topic I wanted to just touch on is the ability of your community to order a building to be vacated. So this is maybe not what you would think of as land use enforcement, which I agree. But a lot of times, if you're enforcing a land use regulation or a zoning ordinance, it may sort of overlap with the building condition being really, really deplorable. And there being some concern about whether it's safe for the occupants to stay in that building. And so your community does have the authority to order a building vacated. So that's given to the health officer up here at the top, the building inspector, and also the fire chief. And the standard is the same for all of them. You have to show that there's a clear and imminent threat. And if the property in question is occupied by the owner and their family, the standard is even higher. And so it's even more difficult to correctly and legally order that building to be vacated. So I don't want to spend a lot of time on this. I'm just sort of noting that is out there, and there's a different standard if it's, renter occupied versus owner or family occupied. So we get a lot of questions about, private covenants. And so, when I say that, I want you to think of there's a deed or an easement that has certain restrictions in it. Maybe there are homeowner association covenants, and those actually cannot be enforced by your community unless they explicitly give that authority to your community. And so the way that it comes to us a lot of times is that one neighbor will come to your town or city and they'll complain about, their other neighbor, and they'll say, we have an HOA covenant, we have a deed restriction on all the lots in this subdivision, and it says, you can't do this, and they're in violation. So we want you, enforcement department in our local community, to take on the burden of enforcing this. And the answer, unfortunately, is, you can't do that. You don't have the legal authority to do that unless the covenant or the deed in question explicitly says town or city can enforce the terms of, of this conveyance. And usually they don't say that. And so that's one of those situations where, I have to say to the client, I understand that you want to help this complaining property owner, the person that brought the complaint, but unfortunately, this is a civil issue. This is a dispute between two private property owners, and it really, the town or your city really has no jurisdiction to enforce that covenant and to take that on. And so it's left to the private parties to figure out. And if I'm being really honest, like sometimes that's the advice that, my clients want to hear. Sometimes that's a way to not have to step into a really nasty dispute between private property owners. But other times it's a really difficult message to convey because there's a real bad situation happening, and it does seem like one property owner is violating, and unfortunately, your town or city just doesn't have the authority to help them out, and so that can be an issue. So I think this is really the last topic for me. And I know this is not maybe directly land use enforcement, but a lot of the land use enforcement that I do deals with junkyards. I think that every single community in the state has properties like that. I know that just bringing that up probably makes some of you picture, certain parcels in your community. So junkyards are defined by state law. And here's the definition right here. It's from 236-112. And it's actually pretty broad. And I think most of the time people equate it with an automotive recycling yard, which is what this picture is showing. But it's not just junked vehicles. Okay. You can have a junkyard and it can be, piles of trash, piles of waste or rubbish or other discarded stuff. That is also a junkyard. I think a lot of your communities probably have separate zoning provisions which talk about junkyards, but it is defined and addressed at the state level as well. And so it's important to note that at the state level, and I'm going to get to your local definition of this in a second, but at the state level, it's not what you do with the junk, okay? So it doesn't matter if you're using that state level enforcement authority. It doesn't matter if the person is not selling the items in question. You don't have to be trying to sell to be considered a junkyard, because that's a defense that we hear a lot. Yes, my backyard is littered with all this stuff, but I don't consider it junk because I sell it on the secondhand market. And so it's not a junkyard. And the court has said that that's not the way this works. There's nothing in the state level that differentiates between, personal items versus items for a commercial nature to be sold. I stress the state level because a lot of communities define junkyard in their zoning ordinance a little differently than at the state level. And if you do that, and your zoning ordinance is not clear that there's no commercial aspect to meeting the definition of a junkyard, you could find yourself in a position where you can enforce the junkyard at the state level, but you can't do it under your local zoning ordinance because your local ordinance may have a carve out, and it may say or may infer that it's only a junkyard if you're using those items and selling them, to make money. So, I encourage you to take a look at your zoning ordinance and just sort of think about that. And if you need to make changes, now's obviously the time to be thinking of that, as the annual meeting season is fast approaching. So let's see, I've got one more thing before I leave this slide. If we are talking about junked vehicles, registration is not the test. The test is whether they're fit for highway use. And so just because it's registered or not is not going to really speak to that standard. I think that shorthand for fit for highway use can be whether it's been inspected. But in some cases, you may need to bring in someone to basically serve as an expert and look at the vehicle and make a determination of whether it's fit for legal highway use. So it's not registration any longer. Let's see. And then this is just one final state level junkyard consideration. They are allowable at the state level, but they need to be licensed, and they need to be you need to get an approval from the governing body that they're allowed in your community. And so at the state level, in some instances, they may be totally fine. Most municipalities, maybe not most, but some municipalities have a blanket prohibition against junkyards. And they say these are prohibited anywhere in town. So depending on what your community allows, the state level licensing, may not be an issue, because obviously if it's not allowed at the local level, then they're not going to be able to legally operate it, because they're not going to be able to comply with the local requirements. And so that means they won't be able to comply with the state level requirements. So again, that was super fast. That was intentional. I want to make sure there's time at the end for questions. That's all that I wanted to say for my presentation. I'll be sticking around until Shane is done. And again, thank you for having me. And at this point, I'm gonna toss it over to Shane. And Shane, I know from prior experience that I'm not gonna touch the stop sharing button at the top, and that you or someone else is gonna take over, and I will just sit here and wait till the end. So it's all you, Shane.
All right, I've taken control. All right, well, thank you, everybody. Can everybody hear me okay?
There's a bit of an echo, Shane.
I know there's been an echo since we started on my end.
Not that bad.
Any tips on what I can do to eliminate that?
I think it's gone now, so keep talking.
Okay. Well, everybody, again, thanks for coming. This presentation is hopefully going to provide a practical standpoint to zoning enforcement through my experience. Everybody might be a little different depending on their city's legal staff recommendations, but this will hopefully at least show you guys what I do from the City of Somersworth standpoint. Oh, sorry. All right, just kind of going over some of the stuff that was already said, but basically I'm here as code enforcement to enforce the city ordinances that have been put in place by people before me. We have folks that take time to create master chapters which help shape city ordinances, which ultimately supports what the community vision is for the City of Somersworth. And the goal here is, of course, to have code compliance, but also to improve property values, quality of life, the public image for the City of Somersworth, and hopefully increase economic development. I will say, code enforcement, it's very situation dependent. I recommend everybody take the easiest route to compliance. It's great to have relationships with all different types of members of the community. I strive to hopefully never have to write a notice of violation, even though that's never going to be the case. If I can at all, I'm hopefully going to resolve an issue, just talking to somebody or face-to-face conversations. Because not always you're going to get somebody to comply to the nth degree. And I'll go over that in kind of some of my examples, but everybody only has so much time in a day, and to be realistic in expectations with code enforcement, it's not going to always be 100%. It might be 95%, or it could be 97%, but you just hope to get close to within the expectations. City members that form those ordinances. So we kind of went over this previously, the formal enforcement strategy and some of the RSAs that apply. I'm not going to go through these because I want to get to my examples, but if somebody has a question, about a specific RSA, you can certainly drop a question and we'll get to it at the end. And there is one note I would like to stress in that when you start a complaint, I would like everybody, just if you are in the enforcement area, just to always assume that the case is going to go to court. And what I mean by that is document everything as best as you can. Take lots of photos that are hopefully time stamped. You know, some of the best times to collect evidence are in the beginning of, you know, the investigation, and not everybody's thinking about where this case may go. All right, so these are just some of the steps. I'll go through them real quick, but you know, you receive a complaint or through some other method, you guys figure out there's a violation. You investigate. Again, assume everything's going to go to court. Timestamp photos. Maybe if you have a complainant, get them a form that they can provide a written notice as previously stated. Just gather as much as you can with the assumption that you'll need that down the line. And I'll show you some examples of notices of violations that I send out, and kind of the further action that entails after that. So I would agree with Stephen. Drone footage is fine, but I would also like to point out that it may become a little contentious that the city or municipality is kind of spying on people. It might not always go well in the courtroom, but you know, if you follow FAA regulations, it is something you could use. So I'm just going to go with the first example here so we can get through. I've got 3 examples. They kind of have different pathways of resolution. So I'm going to move as fast as I can to get through them here. So for example 1, we have a auto body shop that was previously a residential home. They received a special exception to go in this location. During planning review, there was some stipulations that these doors in the rear were to always stay closed. It was fine to bring vehicles back and forth, but you know, on a nice summer day, they couldn't leave them open for 8-10 hours during normal operating hours. So here's a picture of the neighborhood. You can see how close the homes are. You have the back lot of the auto body shop. And what happened was, you know, the building didn't end up having AC, so the shop employees decided to just keep the doors open all the time. And it was a chronic issue, just them leaving the doors constantly open. The neighbors were calling all the time. And that's kind of where I stepped in and started the formal process by issuing a notice of violation. You guys can take a look at this and just kind of see here. We have just a brief introduction, the complaint specifics, and the violation of our site plan regs, chapter 22A, compliance dates. These are all the necessary components of a notice of violation. I'm assuming everybody's probably looks similar, so I won't go deep into the formal, you know, structure of it. But if somebody has questions, feel free to throw a question out. So after the notice of violation was issued, this business continued to operate with the doors open on a day-to-day basis. So from that, I requested that a planning board hearing be held. They had the hearings. The business owner said that they were going to stop leaving the doors open, and I assumed that things were okay. But probably 2 days after the planning board compliance hearing, they were back at it. So I issued a local ordinance citation and summons. This is what one looks like. This was issued here locally at the Dover District Court. I've had really good luck with Dover District Court. I think I've had roughly 70 cases there in the last 2 years. And every judge that I've interacted with has been really great to work with. Over time, you develop a good relationship. And you kind of learn what each judge expects as you go through the steps. So filing a local ordinance citation and summons. So this is what one looks like. Just, I'm not going to go piece by piece through it, but hopefully this provides folks an example. I know some people reached out to me in the last couple of days asking to talk about this component. So feel free to ask additional questions, but basically it just has the basic information of when folks must come to court, the basic information for the court, the violator's name, what ordinance they violated, and the important part here is just to detail with what limited space you have, the details of the violation. Now the civil penalty, I base mine off of 676.17. It's $275 a day, or I believe $550 a day for the second offense. I will say at Dover District Court, I haven't had anybody reject the amount of civil penalty that I've asked for. I think it's dependent on the prosecutor for the case. I've brought all these cases myself to Dover District Court. It's important to just document the long-standing compliance and the issues at hand. I've had most of my cases, I would say, last at least a year. Some cases 2 years to get to this point. When you have a final sentencing hearing at district court, it really varies on the situation. Sometimes we'll just, depending on what the civil penalty is, we'll negotiate and modify the civil penalty, or we'll have contingencies. We'll suspend the civil penalty. In this particular case, the penalty was suspended, but it will be imposed. Basically, I'll go to the court to seek that $10,000 fine to be imposed upon this particular business if that issue were to come up again. So this is kind of the end result. After court, the business owner put in automatic devices that would limit the time that the rear doors to that facility could be open. In this case, it was 2 minutes. So everything from here on is worked as it should, and closed the case out and moved on to the next case. Brendan, do you want me to go through each example, or should I stop on each example? How would you like to break it up?
I think we can kind of go through them. The questions are kind of coming in. It looks like Steven's kind of answering a few of them, and I'll read those out when we get to the end. So yeah, I think just keep going.
Okay, sounds good. All right, so we talked about junkyards a little bit. This is a particular property here in Somersworth that for years had vehicles parked. This is a residential, actually it's a duplex on this particular lot, but the owner also sold vehicles that he wholesaled and brought them on site to sell. A lot of these cars were unregistered and uninspected. They sat here for months, sometimes longer. I got to know the individual, just providing, verbal warnings. He always got the, yeah, I'm going to work on it. I'm going to clean the property up, but it never happened. So unfortunately, you give folks, in my case, many, many months to rectify the issue. But at some point, you have to go through the formal process. And in this case, the notice of violation was issued. Here's another shot of the property. This is after it's kind of I didn't catch it in the beginning, but this is about halfway through cleaning up the property. It used to be chock full of cars, but so here's a courtesy notice that I sent out. I didn't show it in the previous example, but before I sent out a notice of violation, I sent this notice out just kind of informing somebody of the ordinance they've been violating. So basically, I have people all the time just ask, all right, I got the notice. What are the specific ordinances? Because a lot of people do want to know the exact ordinance when they get a violation notice. And again, this is just a courtesy notice. It's not a notice of violation, but we send these a lot out often to folks just to remind them of certain ordinances or regulations within the city. So in this case, I asked to have it corrected by March 1st, 2023, and unfortunately it was not corrected. So I had to issue a notice of violation. That notice was issued on April 4th, and I only gave him until the 15th because I expected the issue not to be fixed. I had been working with this person for, I believe, 5 months at this point. So after dealing with the guy for a long time, I just decided, April 15th was the date. And by the 15th, nothing had happened. So I had served the notice in hand to the individual. And after that, waited a couple more months. I think, June of 2023. As you can see, I give folks a lot of time. I always feel like before you go to court, you should give everybody the opportunity possible, because the judge is also going to expect that when you guys go before, say, a district court judge after filing a local ordinance citation. So this is the form that we use. You guys saw it in the previous example. This case, it was a smaller amount, but it was a $1,000 fine. I tried to negotiate again with the individual before court. Again, nothing happened. So we had a hearing date. I'll just pass the affidavit. Had a hearing date, and we created an agreement at court that the defendant will plead guilty to the violation. He was going to clean it up within a certain amount of time. And if he didn't clean it up, that $1,000 penalty that's been suspended was going to be imposed. So basically, I filed a motion to impose, basically asking the court to impose that $1,000 fine that was suspended back in the initial hearing. And eventually, the court ordered the $1,000 to be paid. It was never paid within the timeline that was ordered by the court. I just wanted to point out, too, we talked about legal fees. This is just an example I provided. But in this case, with the amount of time that was used to enforce this case, oftentimes I will ask for prosecution fees. So here's just an example of I send to district court. I've never had one not awarded after winning a case, but I'm sure at some point there could be opportunity. But this is just an example that went with the case, not this particular one, but so eventually, because he didn't pay, I filed a motion to issue a bench warrant. So after dealing with the person for several months, the civil penalty was never paid. I asked for a bench warrant. The bench warrant was issued. The individual was arrested at one point, and while he was arrested, he had to post the $1,000 bail. And eventually that $1,000 bail was converted into this order here, which basically just converts the bail into the civil penalties. And I don't have an end picture. I couldn't find it on my phone, but it was only until about November of last year. So 11 months it took to have the property cleaned up. So one of the things I like to tell folks, if they ask me about certain things, is when you start a case like this, or really any case, you have the resources to carry something to the end. A lot of times, this case was particularly short, actually, at 11 months. I closed the case today at the Over District Court. That was over 2 years old. Some cases could potentially go longer. I've only been here for 2 years. But I have a lot of cases that typically take about a year to resolve if they're like long-standing site plan issues that have been existing for decades, which is a commonplace, I'm sure, across the state of New Hampshire. Not everybody has the resources to chase everything. So here's a third example I have for you guys today. We received a complaint about a property. The defendant had a sign. The sign up here is at the top. The sign had been there for about 30 years. The defendant placed the sign there After being told by the city not to place that sign there in 1993, the city did some improvements to the road and added a sidewalk where the sign was. So the company then moved it back. After looking to see if the company had a sign permit, I found out they did not. So I did a little digging into the file and I found out that the sign was never allowed. And actually, the city had told the property owner that they were not permitted to have that sign. So for whatever reason, the sign was put in place decades ago and just remained in place. So I issued a notice of violation for the sign. It was an off-premise sign. And we went back and forth with the property owners trying to get the sign removed. And at that point, the notice of violation was issued. I contacted the landowner and they said they weren't going to remove the sign and that it was grandfathered. So a whole, series of discussions ensued about whether or not it was grandfathered. And that they eventually appealed my decision. So we talked about this earlier. The applicant decided to appeal my administrative decision and the notice of violation to state that this sign was in before the zoning ordinance was in place in 1987. And eventually the ZBA ruled in favor of the city, stating that it was not exempt or grandfathered from the zoning rules. So eventually, through about 100 conversations with the landowner, again, they got denied, but eventually, the fence was removed. And those are just some of the examples. I kind of want to breeze through it quickly because I know we only have 13 minutes left, but I'll turn it over to you guys if you want to take control and we can go through some questions.
Yeah, excellent. Thank you. Thank you so much. I know Stephen's been kind of going through and answering some of the questions. I don't know, Stephen, do you want me to read them out? Do you want to go through them?
However you want to do it. I did just real quickly want to say that I 1,000% agree with Shane about trying to work with the people that are on the other end of this. I tell my clients all the time, the goal is not to make money or anything like that. Those are all sort of tools to try to persuade people to come into compliance. That's the real goal. And so, yeah, I mean, I couldn't echo that enough, that it's really helpful and important to try to work with people before you end up in like a court situation.
Excellent.
I could respond to Scott if you guys wanted to.
Yeah, sure. Go ahead.
So the question is, can you explain the process for issuing a citation and summons? Let me just turn my mic down. So in one of the examples of the junkyard, after the notice of violation is issued, there's that time period of when they have to rectify the issue. Once that time period is expired, you can draft the citation and summons. I would go collect additional photographs of the site. And along with that citation and summons, you will need we're going to see if I have an example. I probably can't see it in the screen, but basically you need to have an affidavit basically stating that these are the conditions that exist, what your position is with this, city or municipality or the town, and that the information provided in your citation summons is, best, it's true to the best of your knowledge, basically. So you have the violation notice, you get the citation summons, the affidavit, maybe an attachment or two with photographic evidence of the current situation on the property. For me, I have the same hearing days as the Somersworth police. So the police prosecutor and myself have the same hearing days. So in our case, it's a Monday. So there's a portion at the top of the citation where it says, you know, what the time and date will be to show up to court. That's how I select my time. So it's always a Monday. And you just pick the time. For us, it's always 8:30 in the morning. And then from there, you have to issue it through certified mail or deliver in person. Hopefully that answers your question. If you have any more specific questions about that, like logistical process, feel free to ask another question. Hopefully I can hone in on that piece.
Nice, excellent. Let's see. So we've got another question under RSA 236 111-A. How do you interpret C, that any combination not stored inside shall otherwise comply and shall not exceed 5 vehicles? Are they saying you can have 5 inside and 5 outside, or do the 5 that are not inside still have to be screened from view?
I read that, and that's a really tricky part of the junkyard statute, actually, is the antique vehicle provisions. Just for those that don't know, in state law, there's an exception from being considered a junkyard if you have antique vehicles. That's what's outside. And the language there, I read that as saying you can have no more than 5 outside. But inside, I don't believe that you're limited to any number. If you're storing them inside, then you're not limited to the same 5 quantity. But outside, where people can see it, you're limited to no more than 5.
I would also agree with Stephen. I had a recent court order where the individual had multiple vehicles outside. The eventual order from the judge was just to have one unregistered, uninspected vehicle, but they could have as many cars they could fit, into their barn as possible.
Yeah. And Brendan, I see a couple of questions on revocation in the chat there. And so this is spelled out in statute. It's 676:4-A, and I'll pop that in the chat just so everyone has that. That's the process that your planning board has to follow. And so if you're talking about a non-compliant site to come back before the planning board, if they're unwilling, well, you follow this process and you give them notice that the planning board thinks that they're non-compliant with a site plan or a site plan condition, and that the planning board is considering revoking it. If they ignore that, or even if they come in and they don't persuade the planning board otherwise, then the planning board puts together a declaration that's recorded in the registry that revokes the site plan approval or the subdivision approval. If that approval goes away and they continue, business as usual, that's a violation. They are now operating or, without the necessary approvals from the municipality. And so that would be grounds to enforce against them.
Great. So I've got a couple questions here that Stephen, you already answered in the chat, but maybe just for the sake of stating them out loud for the those who watch this later on, or whoever watches it again, about drone footage. Could you speak on that? And then the second question was about Facebook. Does Facebook account for documenting violations? You already answered those in the chat, but
yep.
Just for
and it sounds like Shane and I agree on this drone one. Yes, you can use drone footage. I think you need to be aware that there are FAA regulations which may limit how you actually use that drone. And if you do that, you're likely to invite a fight a dispute over whether that evidence was lawfully obtained. And so, what I mentioned in the chat is, yes, you can use drone footage, but I think it's easier in the long run and probably less expensive to just go to district court and get an administrative inspection warrant so that you can physically go onto the property and document whatever you need to document. I'd much rather be defending evidence gathered from an admin inspection warrant than defending, aerial footage from a drone. And so I hope that sort of answers that. And then the other one was, oh yeah, Facebook and websites. Yes, if part of what you're trying to show is that a business was operating or a certain type of business, yes, I have used Facebook posts and websites. That can be useful. Sometimes people will claim, I didn't post that on Facebook, so you can't use that against me, or, I didn't create that website. And so it can create a dispute, but, the judge will figure out, what's credible and what's not. But the short answer is yes, you can use that sort of information.
All right, awesome. Yeah, Shane, do you have anything to add? We've got somebody with their hand up, that I can call on them. Unless you have anything to add. Good. Okay. All right. So let's see. Don't see a name on this, but Durham, I see your hand up. I'm gonna unmute you. Allow mic. All right. Can
They would need to unmute themselves too. You allowed
Oh.
the mic. No, they need to unmute themselves to speak. Someone from Durham with their hand up, you can unmute yourself and ask your question. To unmute yourself, the mic is on the right side, top corner. I guess we can keep going until
Okay.
they figure it out. Oh, the hand went down. Oh.
And there's
Okay.
also a question in the Q&A that I don't know if you got to, separate from the chat.
Yeah, let's see it. Okay. From George. Is it required to submit a second and third notice of violation? In Wyndham, I practice issuing 3 notices. First provides 30 days to correct the violation. Second is 14 days. And the third provides 7 days with fees listed as per RSA 676-17. I feel that it at times drags an issue on. I always try to call people first and make sure or make in-person contact to give them a week or two to fix the violation.
There's no legal requirement to send successive notices and give different timeframes. And so you don't have to do that. I guess my sort of view of it, and I'm curious to hear if Shane has a different one, is that as long as the people are sort of making progress, I'm fine if my clients want to give them additional time. But again, the goal is to bring the property into compliance. And so if they ignore the first one, I'm fine sending a second one with a shorter sort of response time, because you're trying to get them compliant, without spending a whole lot of money or time on staff or on legal fees.
Yeah, I guess just to piggyback off of what Steve said, it all depends on the situation and the extent of the issue. If here we are in the fall, and if I have somebody with the site plan and their landscaping's all dead, I'm going to have to give them 12 months, 8 months to get that together, to give them until next spring to get things planted. Or if it's something housing related, like lead paint issues. We cover housing stuff as well. I know how difficult it is to get those certain individuals in that property to do the work required. So I might give them a year in some cases, or 8 months to get that, depending on the scope of the work and the intensity. So it really all depends. If it's something simple like a trash issue, I give them 7 days, which is the minimum.
And then I see a couple of questions in here about a history of non-enforcement.
Mm.
And so I just wanted to sort of address that because I know we're running out of time here. That can be a tough one to give a bright line answer to. If the ordinance in question is very clear, then a history of non-enforcement, it shouldn't be an issue. You can just say, the fact that you've been given a pass for how long that doesn't mean that you get one indefinitely into the future. If what you are enforcing is ambiguous, though, then it gets a little trickier, because if it's ambiguous, they can argue that the history of non-enforcement creates what's called an administrative gloss. And if there's administrative gloss on how something's interpreted, you can't all of a sudden change your behavior unless your community actually amends the provision in question. And so that's kind of a more lawyerly answer than I'm sure you're hoping to get, but it really depends.
All right. So we are out of time. With respect to Stephen and Shane, I do see someone with their hand up. Do you guys have another minute, or do you guys have to?
Yeah, no, sure.
You do? Okay, excellent. Yeah, I can take this question. I'll unmute. Let's see, Audrey, I think. Hang on. Allow mic. Okay, Audrey, I believe you should be able to unmute yourself. And this will be our last question.
Okay, can you hear me?
Yep.
Oh, okay. I had to sign into my Teams before I could run any of these tools. Sorry about that. I had my hand raised earlier. Just a question about the local land use citation and the local ordinance citation. I was always under the impression that for the local ordinance citation under 3139, the town had to adopt an ordinance outside of zoning that was to be enforced, and that the violations within zoning, you use a land use citation. Is that not the case? Because I would love to use the quicker 3139, but my understanding was I could only use that for our trash citation, which is a separate ordinance outside of zoning in our code of ordinances.
Yeah, I mean, I think that 3139-C says if a town has not established this system per vote of the legislative body, then you're limited to the summons as issued as otherwise provided by law. And so I don't know if that addresses your question, or if Shane, you have a different answer.
So I'm not exactly sure what she was asking specifically. Maybe she can clarify.
I'll try. And I know that Somersworth has a lot of local ordinances that they've adopted under 3139, which is a group of types of things that you can adopt outside of zoning. For instance, trash citations, also other things like speeding, like public works things. A certain group of things that you make ordinances that aren't related to zoning can be, and Somersworth has a long list of those. But if you're in a town that doesn't have that, and Durham only has one, that's trash. Anything else, if you're going for the court system, you use the local land use citation, which is for all zoning issues.
Oh, I see what you mean. Yeah.
I just,
Yeah, so-
because a lot of people can use that local land use citation, but they may not be successful with the 3139 local citation because they haven't adopted any regulations.
The 3139D. I think that's your answer. You don't need your local legislative body to have adopted 31:39-D to be able to utilize it.
Okay.
State law gives you the ability to use that.
Aha. Good to know.
Yep.
I think that will be quicker than the process that I go through with the local land use citation. The person can ask for a trial, for instance, and it's, you know, usually many months before I actually get in front of them in the little room before you go in, you know, before you go into the courtroom to make some kind of agreement or adjustment.
All right, excellent. Well, thank you all so much. I've got
Thank
to, yeah, thank you for all the questions. Thank you again, Stephen and Shane. You know, we're really pushing on our boundaries of timing. Thank you all so much for coming out. Yeah, and we've got the contact information for both Stephen and Shane up. And yeah, again, thank you all for coming. Yeah, we'll see you next time, I guess.
Thanks, Brandon. Appreciate it.
Thanks, everyone.